Hey everybody, Josh Sternberg coming at you from sunny Southern California. In this video, I'm going to briefly discuss with you what it means to object to a claim in a Chapter 13 bankruptcy. So it's called objection to claim. Sometimes people call it OTC. And what does that mean? That means if you file Chapter 13 bankruptcy, the court has to determine who's going to get paid. Just because you say, oh, your mortgage company money or American Express money, it doesn't mean that they automatically get paid. Once those companies or your creditors get notice of your bankruptcy, they are required to file what's called a proof of claim in your bankruptcy case. For majority of creditors, there's a deadline to filing proof of claims, which means if they don't file it by the deadline, you could attempt to not pay them because they did not file their proof of claim by the claims bar date deadline. So once you file bankruptcy, that's an important date to know and to watch out for. But people often say, well, who do I pay? How do I know who I pay? I said, well, we got to wait and see who files proof of claims. What if there's a proof of claim filed that I don't agree with? What if it's a credit card that I haven't heard from in 6 years and they file a proof of claim saying I owe them $5,000? Now, the answer to that question is the same answer to any proof of claim question. As a debtor in a Chapter 13 bankruptcy, you have the right to object to that proof of claim. You would have your attorney do that for you. If your attorney represented, certainly something you don't need to do on your own. The attorney would charge you a fee for filing an objection to proof of claim because it's considered sort of additional or supplemental work in the scope of a normal Chapter 13 bankruptcy filing. So you also want to confirm with your attorney, A, if you're being charged, B, how much they're charging you. And then what you would do is you would lay out for the court the reason why you're objecting. Now, let's say it's a 6-year-old credit card debt. You might claim that the debt is no longer due under applicable statute of limitations, which means too much time has passed. The credit card company has done nothing to collect their debt. You as the debtor, the borrower, no longer owe this money legally because the statute of limitations bars them from collecting it. We see that all the time and we're quite successful on that all the time. What if an old business partner claims that you owe them money, but you don't? You could object to their proof of claim and show via evidence that you may have, emails, contracts, signed declarations, that you don't actually owe them that money. Now, a lot of times, if you're filing an objection to claim against like a credit card for statute of limitations, you don't see that much pushback, but you will see pushback, if it's a contentious matter, right? If it's a business partner, an ex-spouse, somebody who does think that you owe them the money, you should be ready and expect some type of pushback on an objection to claim. Also talk to your attorney about, well, what if there's a pushback on the objection to claim? What if it gets set for hearing? What if we have to produce evidence? That could cost you extra money. So you want to make sure that you're doing it on a claim that makes sense. If it's an $800 claim, but it's going to cost you $5,000 in attorney fees, it's a little bit challenging. Real simple, just putting out there what an objection to claim is in a Chapter 13 bankruptcy. We hope that's helpful. Any questions, comments, drop it below. My name is Joshua Sternberg. My company is Sternberg Law Group in California. If you need assistance, let us know. Otherwise, please take this information and give us a like. Thank you.